chat, and we'll definitely answer any question that you have. So over to you, Chido. You can begin your presentation.
Thank you. Thank you. And also again, good evening to everyone. I hope you're well. Um, so I don't need to introduce myself, but just as a precursor, if anybody has a question as I go along with my presentation, please don't hesitate to write it down in the chat, or to raise your hand if you have any questions. I'd like for this to be as interactive as possible. And also, I don't want this to take too much time. So I'm just gonna whiz through my presentation and then we can have a more interactive question and answer session at the end. Okay, so understanding intellectual property, right? I think a lot of us just know of the word intellectual property, some may not at all. So I'm going to start with the, okay, well, our agenda actually is as follows. What is intellectual property? We're going to define it. I'm also going to talk about why it matters to you as creatives. Also going to go into the types of intellectual property there are. And then I'm going to get into the ones that are most important for you as creatives. And then I'm going to go into monetizing your IP in a creative way, how you can do that. And then we'll go into international considerations because I do know that this cohort includes creatives from different parts of Africa. So there are some international considerations because intellectual property, it also, it's a global thing. It crosses borders. And so we need to consider that. So what is intellectual property? Intellectual property is intangible property resulting from creations of the mind. According to the World Intellectual Property Organization, they've defined it as intellectual property refers to creations of the mind, such as inventions, literary and artistic works, designs and symbols, names and images used in commerce. So that is the definition of intellectual property. It is basically the creations of your mind. Anything that you create that comes from your mind, that has been conceived by your mind, is intellectual property, and it can be protected, right? Why should IP matter to you as a creative? So because I've said that intellectual property, it results from the creations of your mind, right? And also, as the word suggests, intellectual property is an asset, right? And so intellectual property as well is an asset to you. Similar to other forms of property, such as a house or a piece of land. So with property, you've got complete ownership, right? And with complete ownership, you also have complete control of your property. So it means that you can sell it, you can license it. Basically, you can exploit it how you please to your benefit. So that's why it matters, because it gives you complete ownership and complete control of the creations of your mind. So your ideas, your designs, your photographs, those are your intellectual assets. And IP rights essentially ensure that you maintain ownership of those rights and you prevent unauthorized use by other people, by third parties. And also you get to set the terms of what it is. As I said again before, you've got control, right? You've got complete control. So you set the terms, whether you want to sell it, whether you want to publish, whether you want to license, it's all up to you. And then also monetization and revenue streams. So your intellectual property rights also allow you to get money, right? So as I had said before, that you have complete control of your IP. So you can sell it if you choose, you can license it if you choose. And when you do that, when you sell your intellectual property or when you license it, it enables you to make money. And also with IP, you can, it helps you to do things like merchandising or brand partnerships if that's something that you're into within your work. And yeah, as I said, copyrights, trademarks, and designs allow you to license or sell your work. And then also it's important, IP is important because it gives you professional credibility and market positioning. So owning your IP reinforces your brand's authenticity. And it also gives you leverage when you're negotiating, right? So for example, if you are negotiating to partner with a brand, it gives you so much leverage to say, well, you know what, my brand, I have a registered trademark. My brand is a registered trademark. And therefore, it's worth something. So it gives you a leg up when you're also negotiating for brand partnerships, for example. And it also just signals that you're serious about your work, because I think a lot of the times, big corporates or big brands, when working with creators, just think that, well, you know, creators aren't really serious anyway, so we'll just take advantage of them where we can. But if you go to a meeting and you say, yo, this is what I bring to the table, I have a registered trademark, and my brand is, you know, legally recognized, then people are also going to take you seriously. They're going to say, oh, you know what, this is somebody that we can trust in the industry as well, because they're someone who takes their craft seriously. And again, it's important because it encourages innovation and it also preserves your legacy, right? So your registered intellectual property contributes to your creative legacy because your work is going to be documented and recognized for as long as your IP exists. And that essentially is creating a legacy and is creating a name for yourself. Because essentially what you're doing is you're building your brand. And it also just encourages more innovation, because if you're able to innovate and if you're able to monetize your innovations or the creations of your mind, if you're able to make money out of it, then you're also able to create more because you are incentivized to do more, because you see that the system is working in your favor. And then the last reason why IP should matter is for risk management and general legal protection. So when infringement happens, and it often does, right, your IP rights provide that legal framework for you to be able to respond when somebody infringes on your IP. You're able to say, no, cease and desist what you're doing. You're able to pursue claims for damages because you have a prima facie right. When we say prima facie, we mean on the face of it. So if you were to have, say, for example, a trademark registered, you'll have a certificate to show that it is a registered trademark and it is in your name. Therefore, you do have a right to this. So it does help when legal trouble comes. It's a risk management tool. So we're going to get into the types of intellectual property. We have copyright. Copyright is a legal term used to describe the rights that creditors have over their, that creators have, over their literary and artistic works. So when we talk about literary works, we're talking about, it ranges from books, poems, spoken word, and then also artistic works are like music, paintings, sculptures, films, computer programs and databases also can be covered by copyright, as well as maps, advertisements. You can do like architectural drawings. All of that can be covered by copyright. And then we have trademarks. So a trademark is a sign which can be in the form of a name or a logo that distinguishes the goods and services of one enterprise from the other. So a good example of trademarks is like Fanta. Fanta distinguishes that it's an orange drink that's derived from the Coca-Cola company. But then Mirinda is also an orange drink that has been produced by the Pepsi company, for example. So the trademarks in this case, in my example, are Fanta and Mirinda. So the goods are orange juice or orange flavored fizzy drinks, but Fanta distinguishes from Mirinda, for example. And then we have patents. A patent is just an exclusive right granted over an invention. Patents are quite difficult to get in the sense that there's a lot of the requirements are that it has to be novel. So it has to be something that has never been seen by the human eye. And that's very difficult to prove that we actually haven't seen this before. So it has to be new, it has to be novel. And the examination process, for example, is also quite stringent because they'll need experts to kind of reproduce what you say is a new invention. And then they, after they've reproduced it, will be able to say, yes, for sure, this is a new invention. And then we also have industrial designs, which are, these could be like 3-dimensional designs or 2-dimensional designs. They constitute like ornamental or aesthetic aspects of an article or of something. So what that means is that, for example, your office chair, right? The ornamental or aesthetic aspect of how that office chair was designed is what is an industrial design. Industrial designs can also be coffee tables, the way that it has been designed. If it's a new kind of way of looking at or designing coffee tables, you can have an industrial design over that. There are industrial designs over bottles. For example, For example, the Coke bottle actually has an industrial design registered for it. And then also the other types of IP, you've got trade secrets. So that's just essentially confidential information, which may be sold or licensed. So, for example, the recipe for the Coca-Cola drink or the KFC recipe, those are trade secrets. And then you also have geographical indications. And these are just, this is IP used on goods that have a specific geographical origin. For example, we know that sparkling wine that's called champagne only comes from the Champagne region of France. And the tea that we call rooibos comes from the rooibos region slash farm. It's a specific combination of herbs and or spices, whatever, that are made specifically in South Africa that constitute rooibos tea. So you will never find, if Zimbabweans start making a tea that's similar to rooibos tea and call it rooibos, that is incorrect because the geographical indication for rooibos only belongs to South Africa. So now that we've kind of gone through all the different types of IP, I want to just narrow it down for you guys to two types that are most important to creatives. I did go through the profiles of the cohort members, and I saw that there's a lot of photographers, there's a lot of filmmakers as well. So I figured let's just hone in on copyright and trademarks. So copyrights. These are, I've just kind of synthesized it to 6 items that you need to know pertaining to copyright. So there is no copyright on ideas. What that means is that you cannot have copyright over an idea. If it's something that you have thought about, maybe you've conceived a story that you'd like to shoot as a film, right? It remains just that, an idea. But once you convert it into material form, then it becomes something that is worthy of copyright, right? So you can't say, if you shared an idea with your friend, oh, this is what I want to do, this is how I want to do it, and then your friend goes and acts on that idea, you cannot say your friend has stolen your copyright, because copyright subsists in something that is material. So you cannot have a right over an idea, right? And then also, copyright is automatic. Back to the not having copyright over ideas. I think it's important to document your work, right? So, for example, as I said, if you come up with a concept of something, it's so easy to just say, oh, I've got copyright because I have an idea, but you don't. So I would suggest that you need to document your work in order to prove originality and claim ownership, right? Because if you don't reduce it to a material form, then it just remains an idea which nobody can really prove that it's yours or not. And then number two, copyright is automatic. So it subsists by operation of the law. There is no requirement for registration. What I mean by there's no requirement for registration is that you don't need to apply to some government office for copyright of your work, right? This does depend on national laws, though. So you need to make sure that you check with your national laws what their requirements are. Because, for example, in Zimbabwe, copyright subsists by operation of the law. So as long as I have published a book, the copyright already attaches to that work automatically. And also this is not, registration is not a requirement according to the Berne Convention. So again, you just need to make sure that you dot all your I's and cross your T's. Ensure that you know what your law says about copyright. Another method, which is a bit old and archaic, but it also works, it's called a post box method, where I don't know where you guys come from, if your post offices still work, but sometimes whenever maybe you've written a manuscript for your book or you've written a script for a film, you can type it out and print it out and then kind of send it to yourself via the mail. That way, there's a date attached to when it is that your copyright starts to take place. Yeah, and then number three, ownership of copyright where commissioned. So by default, we all know that if you are the owner of, I mean, if you create a work, so for example, you create a painting, you take a fantastic photograph, or you write music or whatever it is, right? The default position is that whatever work, that artistic work or literary work that you have created, you own the copyright. But in some instances where you have been commissioned by someone, so for example, you are working with a company and they've commissioned you to take pictures. Maybe you're working with a wildlife company and they've commissioned you to take wildlife pictures. The ownership of that copyright now actually belongs to the person who has commissioned you to do that work. So if somebody pays you and says, this is what I want you to do, that the copyright then belongs to the person who has commissioned you to do the work. Similarly, if you are employed under someone and maybe you've written a script, perhaps you're employed with Walt Disney and you write a script for Walt Disney, then the copyright belongs to Walt Disney. It does not belong to you. Why? Because you wrote the script while you were employed under Walt Disney. Therefore, everything that you produce under their employ belongs to them. So I think Kuda mentioned this yesterday when she said that you need to be thorough in your contract, right? So unless you negotiate otherwise, but a commissioned work is usually, the copyright usually belongs to whoever is paying you to do the work, unless you agree in a contract that the copyright will remain with you. So you need to make sure that these things are ironed out before you actually get into doing the work. And then also number four, ownership of copyright in collaborative works. I know that a lot of creators work together and collaborate for so many things, which is great. But I've also experienced situations where creators start fighting with each other because there was no clear cut, um, there was nothing clear cut in their partnership agreement that said the IP will belong to so and so, or the IP will be jointly owned. So you need to clearly set out who does what, and if the IP is joint, right? So for example, if you are collaborating on a song, or you're collaborating to write a book, um, it's so important to have a contract that is clear to say person A does this, that, and the other. I've seen this a lot with filmmaking, where as a filmmaker, maybe uh, you are directing and you're also producing, right? But then maybe you hire somebody, or you partner with a friend who's also a filmmaker, and you kind of come together to create um, a single body of work. But then you find that one person did more work than the other. And even when it comes to like compensation, now it's like, how is it fair that we split 50-50 when A did 80% of the work and B did only 20%? So as Kuda was saying yesterday, there is need for you to create contracts or draw up contracts and agreements that are clear, that specify what duties each one has, and that also specify how you're going to deal with the IP. If you own the IP jointly, then it means that even when selling, both parties or all parties need to be involved, need to have agreed that we're selling this IP. All parties need to then be able to benefit from the monetary gains that you would have gotten from that IP. So it's so important to ensure that when you're collaborating, you have a clear-cut contract that stipulates all of these things. And then also copyright and AI. I've mentioned this, I've included this rather because I think it's important, because I've seen a lot of creatives now incorporating AI into their work. So it's important to talk about the legal complexities of AI and copyright. Because the question of who owns the intellectual property is a hot debate. Because I think I'll give the example of I don't know if you are all familiar with the song that came out, the AI song that came out that sounded like Drake, but it's not Drake, right? Barring the infringement on Drake's personality rights, the question is who owns the IP to that song? Because probably that song did make quite a number of streams and generated quite a few dollars. So then who benefits from the IP of that song? So it's important to kind of figure out what your particular jurisdiction says about artificial intelligence. So for example, in the United States, the position is that artificial intelligence generated works cannot be copyrighted unless there is substantial human authorship. But in China, for example, they have a more progressive stance, which says that artificial intelligence generated work can actually own copyright if you're able to show the originality of the work. So you see, in China, artificial intelligence can own copyright, but in the USA, it cannot. So it's so important to know what your specific country is saying so that when you do, or if you do end up using AI to generate an original work, you're able to still benefit from it. And then number 6, infringement does happen. So you need to just always be prepared at all times, right? Because there's always going to be someone who copies, someone who reposts or remixes your work without your consent. So knowing your rights in terms of copyright means that you're able to then take action. If it means that you are getting a takedown notice or you're writing a letter of demand, whatever it is, if you know the rights that you have, you know that, oh, okay, my copyright subsists automatically. So therefore, the day that I publish whatever work that I've published is the day that my copyright starts working, for example, or my copyright is activated. Then if anyone who comes after that date copies your work or whatever, you can easily then take action. And also, now we move on to trademarks. So as I said, trademarks, they are essentially a badge of origin, right? And what's really important about trademarks is that they need to be distinctive. You really have to be creative about what it is you want to trademark. If it's a logo, I'll tell you this from my personal experience, professional experience, that it's so worth hiring someone or just taking the time to actually come up with a logo that is unique, that has never been used by anyone before. I've seen in my line of work people using logos of chicken. Like, for example, they'll use like a chicken on their logo. And I mean, cool if you're selling like chicken, fast food or whatever, but it's been done before. And also you can't use a chicken exclusively to the exclusivity of others, right? Because the next person will also open a chicken shop and also use a chicken in their logo as well. So you need to be creative in terms of coming up with logos, coming up with names, even your business name. It can't be descriptive of what you do. So it can't be Chido filmmaker, right? Maybe Chido is a bad example. It can't be good films, filmmaking, because then that's something you cannot get a trademark over that, because the first requirement is that it needs to be distinctive. So when you call your company Good Films, then it's descriptive of what you're trying to do. But if you're to call your company, I don't know, come up with a name, maybe an acronym or something cool. I think you guys are creatives. This is in your wheelhouse, basically. So my advice to you is, when coming up with a trademark, particularly a logo for your, maybe it's a logo that you're going to put on your photographs, make it unique, because you're able to register that. And I'll tell you now, you'll be able to use it for anything. For example, you could be a photographer with a really cool, unique logo that you use as a watermark on your pictures. And you can then decide 10 years down the line, oh, you want to get into merch. Then you can start using that logo on clothing items, and that could really pop off, and it could be a new avenue that you had never thought of. So whenever you're creating your trademarks, whether it's a name, whether you're coming up with your name, it really needs to stand out. It cannot be descriptive of what you do. For example, Nivea for cosmetics. Like maybe it means something in German, but to me it seems like a very unique name. Like who would have ever thought? And if anyone else comes and starts selling cosmetic products like lotion or whatever using the word Nivea, it's so easy for them to clamp down and say no, because everybody, like the whole world knows what Nivea is. So this is a really good opportunity for you to be able to put yourself out there in a very distinct manner. And then number two, trademarks can exist in perpetuity, um, which means that you can have a trademark forever, right? Um, for as long as you just renew your trademark every 10 years, then you can have it forever. For example, the Coca-Cola trademark has been in existence since 1893. So that's a really long time. And it's because they just continuously just pay their renewal fees. So that's what I mean by you can have IP in perpetuity, particularly trademarks. Um, and then also, again, remember, as I was talking about the way that you come up with your logo or the way that you come up with your business name or brand name or whatever, that all speaks to brand strategy, right? The uniqueness of your logo or your trademark is where your brand lies. I think Kuda said this yesterday as well. You need to work with the end in mind, right? You need to have a vision of where your brand is going and then strategize accordingly. As I said, you could be a photographer, but with a really cool logo, and then you end up actually getting into sportswear, apparel, whatever, because your logo is so cool. It's so, um, specific, and everybody can identify that this is who you are with that. Uh, so yes, now monetizing IP creatively, right? You have licensing, merchandising, partnerships as options for monetizing. Um, with licensing, right, you can offer usage rights for your designs, for your photos, um, or brand assets, right, under controlled conditions to third parties. So essentially, you can license out your creative products for a fee, right? Um, you could, yeah, maybe your film, you can license it out um to cinemas like Ster-Kineko or whatever, and they'll pay you for whatever a controlled amount of time or whatever. You can stipulate the conditions that you want. But yeah, licensing is a really good way of monetizing your IP, merchandising as well. I think I mentioned when I was talking about the logos that you can then get into something that you never thought you could. That's merchandising, creating merch around your creative products. You can create merch around your photos. You can create merch around just your brand itself. I think we've seen even with artists, musicians who, when they release an album, they then create merch, right? Hoodies and caps and bucket hats and all that. That also brings in some kind of income, right? And then you have partnerships. So your brand's IP becomes leverage in collaborations. I think I said this in the beginning to say that, when you're now collaborating with corporates or big companies, you're able to say, hey, this is what I bring to the table. I have, I have brand IP, and so it's worth something, and that should be considered when you're also going into partnerships. And then we'll go into the international considerations real quick because I don't want to keep you guys here for too long. So I think I said this before, IP protection is different in, ooh, sorry about that. It's different in different countries, right? The requirements are different in different countries. IP rights are jurisdiction specific. So protection in Zimbabwe doesn't automatically extend to the same kind of protection in Kenya or Zambia or Nigeria or South Africa. So number one, you really need to know what your country specific laws say about what you can and cannot do and what the requirements are. And also you must register your rights. So for example, if you are a filmmaker or whatever, you want to register your trademark in the countries that your films are going to be showing. For example, you are showing your films in Zimbabwe and South Africa and Zambia. It would be prudent to register in all those countries that you want your work to be seen in. Because as I said, it's country specific. Just because you've got your IP registered in Kenya doesn't necessarily mean that it's going to be recognized in Zimbabwe. So the best thing for you to do is, if your work is starting to grow on a global scale, then it's good to then identify, which countries is my work going to be showing, okay? And then also, how do I register in those countries so that I am protected in all the countries that I'm going to be functioning in? And then also global IP treaties. I've spoken about the Berne Convention. The Berne Convention is the treaty on copyrights. It essentially offers automatic copyright protection in over 180 countries without registration. So, for example, with the good thing, I suppose, with copyright is that if you have copyright in Zimbabwe, then it's applicable in Kenya. If you have copyright in Zimbabwe, it's applicable in France because those countries are part of the Berne Convention. And also with trademarks, you have the Madrid Protocol, which basically simplifies international trademark registrations through a single application. But that is quite expensive because you'll be paying in euros. And then global distribution risks, right? With online content now, so such as photos, music, videos, it's so easily accessible on a global scale, right? And that increases the risk of unauthorized use. So you need to consider digital watermarking, and you need to make sure that you are very aware of the app specific protections that are available. So such like your takedown procedures on Instagram or TikTok, you need to be very aware of what those are so that if anything happens on TikTok, you're able to quickly take action. So my practical suggestion for you is that whenever you're putting your work out on the internet, it's so important to put a digital watermark. If it's your photos, if it's videos, or whatever it is, it's so important to have a watermark. That way, you're also making it difficult for people who are trying to copy. And then also there are cultural and legal differences per country, right? So obviously, things like indigenous knowledge and traditional expressions, those can be protected differently. For example, in Zimbabwe, we do consider indigenous knowledge as intellectual property. And so there are some things that, like folklore, like Shona folklore, some of them you cannot register. So you need to be very aware of what it is in your country, cultural and yeah, like cultural things that you can register and that you cannot. Um, so yeah, that is the end of my presentation. I probably will just, I suppose, first go through the questions in the chat, and then if there are any other questions, we'll kind of go from there. Uh, okay. How effective are trademarks or watermarks on images in protecting one's work from being stolen or misused, and how authentic or legally binding are they when it comes to proving ownership? Okay, as I said, watermarks on images are are encouraged, right? Because as I said, again, it makes it difficult, number one, for the person who is trying to copy your work to copy it properly. And number two, it does show a sense of ownership. Uh, I think it would work if, for example, your business logo is the same as your watermark. For example, if your watermark is uh, Chido Picks, and then my business is Chido Picks, then it helps to show a link between the work and the person that is supposedly the owner of the work. Um, and also how authentic or legally binding are they when it comes to proving ownership? Legally binding, iffy, but it really does go a long way in proving there to be a link between the person who has created and the work. And then also, are there specific apps or tools one should use to create watermarks that are legally binding and recognized to help one's work not to be stolen? Um, to be honest, I actually don't know if there are any apps that can be used. I would like to think that the answer is within your peers, because I'm sure there's somebody who's been able to crack that code. If you're able to encrypt your work, all the better. I don't know if that will also kind of um, distort your work in any way. But I think the answer to that is actually through peer engagement and finding out what others are doing. Because from our perspective as lawyers, that is one of the best ways to kind of avoid um, situations where people copy or steal other people's work, especially when your work is posted online. And then the other question is, do the agreements you mentioned only cover IP registered with organizations like Aripo, or the local registrations too? Do we have ballpark figures on how much this could cost? Um, okay, I'm assuming that this question relates to um, what I was talking about, the Berne Convention and the Madrid. Um, I hope. I don't know if you can clarify. Okay, I'll just respond to what I think the question is asking. Um, so with registration, you have two options, right? You can choose to register in your local country, which I would always suggest you do, because number one is cheaper. And as I said, IP is country specific. So you're better off registering with your local IP office. So that is for your trademarks. And then you need to find out if copyrights are registrable in whichever country you're in. And if you need to do that, then you do that. But yes, I would always suggest that your first stop be to register with your local office, your local national office. And then there are organizations such as Aripo. Aripo helps in the sense that it's just one organization that helps you to file in several countries at the same time. So, for example, with trademarks, you can do one application in 13 designated states, 13 states in Africa. But it's not all African countries that are a party of the Banjul Protocol, which is what regulates trademarks with ARIPO. So you'll find that sometimes the country that you want to register a trademark with via ARIPO is not a party to ARIPO. So as I said, it's always easier to start with your local registry office and register from there. Ballpark figures on how much this could cost. What I do know is that with Aripo, one application in 13 designated states, because it's usually charged per designated state. So, for example, $50 per state. So the fee goes up as you increase the number of states you want to register in. The same goes with Madrid Protocol. I think that's even 100 euros or so per state, per country that you want to register in. Whereas with local registries is usually charged in your local currency. And in some instances, like Zimbabwe, they do have concessions for small to medium enterprises where the prices are even cheaper. For example, in Zimbabwe, uh, it could be 100 US dollars or less. Now, I mean, 100 US dollars to 200 US dollars for small to medium enterprises or individuals. For individuals, it's even less than that. So there are some countries that have made concessions that will allow individuals and creators to register their trademarks, particularly at a lower cost. Their trademarks, their patents, industrial designs at a lower cost. I know this is relevant in Zim. I'm not sure of the other countries. And I think there's no more questions in the group, in the chat. Um, are there any other questions?
I think there's no more questions, and we have officially run out of time. So if anyone does have any extra questions, Chido, I'm sure that there's a contact number that you shared with us. We can share it with the group.
Yes.
Is that fine? Okay, that's great. Thank you so much for your presentation. We definitely learned a lot and we gained some valuable insight into the world of intellectual property and how to strategically, legally protect ourselves just so that we can have some long-term success in our creative businesses. So thank you so much for taking the time to teach us about this, Chido. We really appreciate it.
Thank you for having me.
And for everyone else, that is the end of Creative Business Studio week 3. We don't have any sessions tomorrow or on Friday. The next session is next week, Tuesday. And I believe the conversation is going to be about, if you could hold on for a second, my screen is going off. Okay, quickly. It's about AI for creative business. So that's going to be a very interesting topic. And Taku Nakwenda is the one who's going to be leading us in that conversation. So thank you everyone for joining. Uh, that is it for today's session. Until next time, have an amazing Wednesday evening.